Who Owns the News? A History of Copyright from Stanford University Press. This is a wonderful book focusing on issues that are of intense current as well as historical interest. I am a current fellow at the Society of Fellows. You are a previous fellow at the Society of Fellows. We have 2 previous fellows here and 1 current Columbia professor who I will introduce right now. I just wanted to note that I'm both a historian of Latin America and a working journalist, so I found your book incredibly engaging on issues that I take for granted, such as accreditation, norms of citation, and also the financial structure that is often so invisible to both journalists and readers, but absolutely crucial to the way that news is produced, sold, and consumed. So without further ado, a few introductions. Will Slauter is an associate professor at Université Paris Diderot and a member of the Institut Universitaire de France. He was a postdoctoral fellow here at the Society of Fellows from 2007 to 2009 and occupied the office that I now occupy, as we just learned. Writing this book was supported by fellowships from the John W. Klug Center of the Library of Congress, the National Endowment for the Humanities, and the American Antiquarian Society. Kevin Lamb, we're actually going to do, Will is going to be able to introduce his book, and then we're going to have comments in order, so Kevin is going to go next, and then Richard. So Kevin Lamb, I understand, was at the Society of Fellows at the exact same time as Will Slauter, so this is a reunion of sorts. And he is a literary scholar and a lawyer. A former literary scholar and a lawyer. Okay, just a lawyer. He holds a PhD in English from Cornell University and is now a litigation specialist at WilmerHale. And finally, last but not least, Richard John, thank you for joining us, is a historian at the Columbia History Department and also advises students in the program in communications. His publications are enormous, and so I will not list all of them. I'll just mention 2 relevant monographs. The first is Spreading the News, the American Postal System from Franklin to Morse. And the second is Network Nation, Inventing American Telecommunications. And his work brings together the history of capitalism, business, and communications. So the way this will be structured is that Will introduce his book with a few slides to accompany. And then Kevin and Richard will each have about 10 minutes to respond. Will respond, we'll have a dialogue, and then we'll open it out to questions. So, Will.
Okay, thank you very much, Rachel, and thank you to Kevin and Richard for agreeing to read my book and prepare some remarks. I'm very happy to be back in this room in particular, and to thank Eileen Galuli and all the staff of the Society of Fellows and the Humanities Center here, because this project began in this room. And when Kevin was here, and we were together, one of the things we did was organize a spring lecture series on the theme of intellectual property. And at the time, it was just kind of an interest that sort of intersected different fellows' work, and I didn't think I would spend the next 10 years working on the history of intellectual property, but I did. And so I want to take us back to that moment in 2009 in this room. You know, that was a year where there was quite a lot of talk about the crisis in journalism, and in many ways that crisis has not gone away. It's taken on new dimensions since that time, but some of the underlying problems, in particular financing original reporting, has not gone away. And so there were a lot of pronouncements about how, you know, basically we're on the verge of a world in which quality journalism could disappear if we don't do the right thing. Also in that year, in 2009, was when I noticed that news organizations, prominent ones like the AP, and of course Murdoch's News Corp and other publishers, talking about aggregation as theft, talking about how new models of disseminating news, this was really, you know, Facebook barely existed and nobody was talking about it. Social media was not what they were talking about. They were talking about aggregation like the Huffington Post or Google News or Yahoo News. But anyway, you had this sort of debate between, well, what is the web? What does the web enable? What can we do? And if we do it certain ways, might we lose quality journalism? Much of the attention was on these aggregators, and in some ways that's still where a lot of the attention is, even though I think in terms of the news ecosystem we've moved on from that, and social media is much more important than an aggregator like Google News. But in any case, as a historian, what really struck me was that, in some ways there's a whole strain of news publishing which is compilation and juxtaposition, or what we might call aggregation. I've put up this image of an 18th century newspaper called the Grub Street Journal, which was a satirical newspaper. And what it would do is it would take short snippets of news from 8 or 10 London newspapers, and it would follow a story and give the details that were being reported in each of these newspapers. And so even this is a sort of coverage of the royal hunt, and so the difference between the newspapers there is very minor, what they hunted or how long it lasted, and that might not seem important, but even for such a mundane, routine story, the Grub Street Journal was pointing out that the version of the news that you got, depending on which newspaper you read, and the fact that they all contradicted each other was made plain by compiling and juxtaposing visually for readers to have an overview. And indeed, this manual form of aggregation led the editor to be accused of piracy. And he defended himself against this charge of piracy by saying that the way we are comparing different articles and putting them on the page is actually very useful for the public and might even be necessary to put a stop to the currency of false news. So one way we could think about the history of copyright and the history of norms related to copying journalism could be a history of these kinds of arguments. And so much of the book is a kind of, there's a strand of intellectual history of the different arguments that are used for and against some kind of a property right in news. This other quote I put up there is from the middle of the 19th century, when the news business had changed. Now there was a telegraph, now there were other forms of disseminating news, and there was an attempt to create a special copyright in news that early in 1855. And it was, vigorously opposed by a lot of newspaper editors who said that, well, actually, if you do something like that, you're potentially restricting the flow of what they called intelligence. And so that shouldn't be piracy. So that's one strand of the book, is a history of the different arguments that were used for and against copyright. Another thing that you'd often find in a legal history, but which I think, downplay a little bit in my book, is just the basic history of legislation. Because if you did look only at the history of copyright as a history of legislation, you might see a kind of chronology like this one. Well, at what date were books protected by copyright? And then how long did it take before newspapers and news articles were protected by copyright? And if you look at something like that, it looks like it's a history of either an inevitable expansion, at which point everything eventually becomes a kind of intellectual property, or it's some kind of a history of delay in which we need to understand why news articles were protected so much later than books. So that's part of the story too, is actually recreating the various attempts and the different legislative attempts over time and how people oppose them. But I wanted to move beyond that. I wanted to include also a history of copying and a history of news that would look beyond just the legislation and the cases to strategies of publishers. And here one of the main lines in the book is the way in which the main subsidy that financed journalism for so long was not copyright. It wasn't a law that said you couldn't copy. It was the ability to use news to attract advertising revenue. And this, in a way, is what made it possible to make money publishing news, even though news has always been very easy to copy. So I trace sort of some of the basic components of that, going back to the 18th century, and namely here, we've just got an example of a typical 18th century newspaper where once you look closely at it, you see it's made up of all sorts of texts copied from other publications, also some original material that was collected locally, but it was really this collective work, this miscellany, that was bundled together and sold to customers with up to a half of the page space being advertisements that really explained the profitability. I also wanted this to be a history of editorial practices, like the cultural sort of work of doing working with newspapers. And you have up here an image of this delightful scissors editor. For most of the 19th century, on both sides of the Atlantic, this was the main sort of image of newspaper work, was an editor with a pair of scissors and a pot of paste. And it was because literally this was a step that you would take if you were going to create a mock-up of the next day's paper. You might take some of the material from a newspaper in another city, clip it out, add some new local material, and so on. And on the right you see at the American Antiquarian Society, they have a lot of these newspapers that were used by editors in the 19th century, and you can see where some of the cutouts have happened. And there's a legacy of that, because if you look on the digital version that's been sourced from that library, that poll is still there on the digital version as well. And it's because somebody, in order to find it, you have to go and find the editor which copied it. So editorial practices in addition to legal history and business history. This newspaper work during much of the period I'm studying is one in which news is treated largely as a shared resource. And here you have this quote from a London editor in 1835, said, "You want to put a copyright on news, but we're all copying from each other on the very day of publication. And readers know this, and it doesn't stop them from buying the newspapers. In fact, it may be what enables us to do our work." Now, a lot has changed since 1835. Journalism became a profession, the business models have changed, and so on, but I would argue that copying still remains absolutely central. The best analysis I've seen of this is not for the US or the UK, but for France, where an economist named Julia Cagé worked with computer scientists and built a database of every news article published online in French in the year 2013. And this is not aggregators. These are major newspapers like Le Monde and Libération, all the radio stations which have their own news websites, pure internet players that just produce journalism online. When they ran plagiarism detection software through this database, they found 2/3 of French news articles in 2013 were pure copied and pasted. If you expand that to include like things that are reformulated, right, or slightly reworked, it would probably be much higher. So one of the reasons that news is hard to protect through copyright, and one of the reasons that so many of the struggles in my book are ongoing, is because the main commercial value of news comes from publishing it immediately, and the time advantage that is gained by being the first to announce the news. And so a lot of the arguments that news publishers make, that I recount in my book, are about this time-sensitive nature of news. And I would argue that for society, it's also, the value of news, the social value, is also time-sensitive. And so I try to look at some of the ways in which news was consumed and shared in different environments in the 18th and 19th centuries especially. Well, today, 10 years after starting this project, a lot of the issues haven't gone away, as I've said. As we speak, the European Union is putting the final touches on a new copyright directive. And this copyright directive has a special provision for news, which has turned out to be one of the most controversial measures in the whole package. And a lot of members of the European Parliament have said they've never received so many calls or emails about something as obscure as copyright. They didn't expect this. And in watching this debate, I found that it's been extremely polarized politically. On the one side, you have publishers who claim that we need stronger copyright to protect journalism, that this would be the way of, as they say, a sustainable and free and pluralistic press in Europe, which is endangered by American social media companies and American tech companies. So you have on the one side this, if you believe in a free quality press, support this stronger copyright. And on the other side, you have organizations as reputable as the International Federation of Library Associations, the IFLA, saying that this Article 11, this special copyright for news, is a threat to an informed and literate society. And what I see as a historian looking at this polarized debate is that copyright has always been very politicized, and copyright has always masked underlying realities which are much more complex. It's not just about being for or against quality journalism. It's about taking a closer look at how copyright actually works and how the business of news actually works. So I think I'll end there and let our commentators discuss.
You're up.
Yeah. Will Slaughter's Who Owns News Who Owns the News is a beautifully crafted, tightly argued, and morally engaged contribution to small but growing literature in the political economy of news, public information, in the Anglo-American world. In the few minutes I have this evening, I'd like to comment on it in the context of the history of journalism, as it's understood, not only at the Columbia Journalism School, where I teach a core course for our MS students every year, not only in that context, but also in the context of history, media scholarship, political sociology, and political theory, who specialize in the history of news. So two different groups. Let me begin with what I take to be the received wisdom, or the narrative, at the Columbia Journalism School. Like most professional programs that are designed to train the rising generation of journalists, Columbia Journalism School emerged early 20th century. We celebrated our 100th anniversary in 2012. And emerged in a world in which it was taken for granted that is to say in 1912, which the newspaper had always been and would always be the primary medium for the circulation of news, a newspaper-centric project. Joseph Pulitzer, the world. Until he was the benefactor of the journalism school. Until quite recently, these assumptions bore at least some relationship to reality. As recently as around 2000, maybe more recently, depending upon which study you read, a high percentage of the most consequential news stories, often as high as 80%, that end up in television or radio or social media originate as newspaper articles. Right? So the news is coming from a relatively small part of the news ecosystem until quite recently. And this always startles my students. I just happened on Monday to put this table up. The peak year for advertising revenue for U.S. newspapers was 2006. Okay, so that was going up until 2006 and it falls off. All right. Facebook starts in 2004. Thus, it's perhaps not so surprising that for decades journalism students have been taught how to write newspaper articles, a task they learned boot camp style in the most famous course at the J School until recently, RW1. We abandoned RW1 just about, I think it was 3 or 4 years ago. And in such a world, it wasn't entirely bizarre that journalism history was newspaper history. Journalism history was newspaper history. The history of magazines, radio, and television kind of shoehorned in where they best fit. Kind of journalism and mass communication kind of reflected that. It's a very strange world to be teaching and researching in because the field has no intellectual coherence whatsoever. Journalism and mass communication basically meant newspapers and everything else. Well, Slaughter shows just how time-bound and indeed how parochial this narrative was, Britain and America, two countries that provide the evidence for this study, and it makes a lot of sense to study Britain and America together if he does so well. Now, why is this? Why is it so parochial? It's by no means inevitable that in 1700 the newspaper would be the primary news medium. And in fact, the newspaper would not become the dominant medium for selling news until the middle decades of the 18th century. That's a long time after the printing press, right? So mid-18th century, then maybe to, what, 2005, 2010, wherever you want to put it, 19, you want to put it with cable news. Long run, but just over 2 centuries. The rise of the newspaper was more or less coeval with a number of quite specific events, including the opening of legislative assemblies to reporters, which happened in Britain in the 1770s, the United States in 1789. The Constitutional Convention was in private, off bounds. It was widely assumed that had the proceedings been public, had journalists been present, the movement to draft the Constitution would have failed. And we're even skeptical of whether there were reporters at that time as opposed to journalists. Journalist is an older category than a reporter. We often associate beginnings of reporters with this kind of reporting on legislative assemblies and then on courts. So that's one thing, contingency. In addition, the newspaper in Britain and America was closely linked, Slauter shows so well, to two institutions that aren't really directly connected to the creation of news. Narrow. That is to say, first, advertisers, and second, the postal network. Many early 18th century English newspapers have post or mail in their title, and the same was true in the United States. It's not self-evident that advertising and the postal system are going to be so central, but they certainly are in Slaughter's story. Now, Andrew Pettigrew, in his splendid invention of the news, has written about certain aspects of this story, as Will knows. This book, among its many virtues, is a beautiful tour through the footnotes to all the literature on this subject that you need to read, including Pettigrew. That's a fine book. Yet Pettigrew stops in the 18th century, which is more or less where Slaughter picks up steam. He doesn't say he doesn't have a lot of interesting things to say about the 17th and 18th century. The real strength of this book is the 19th and the 20th. All right. So let me say something about the origins narrative. Three things. First, there is no pre-lapsarian, pre-commercial moment in the history of the Anglo-American newspaper. This is a mistaken assumption baked into Habermas's structural transformation of the public sphere, a title that revealingly, and I think it's good riddance, does not appear in Slaughter's index. This assumption is an unfortunate legacy of the viscerally anti-commercial Frankfurt School, of which Habermas was a member. Okay, so there is no pre-commercial moment. In fact, there's a lot of, you can actually start looking at The Spectator, which is about as far back as you can go with Habermas's commerce there too. That's one. So it's commerce from the beginning, and as Will showed so well, it's this odd bargain that you're paying a high percentage of the newspaper revenues coming from advertising, yet we think of it as news, and the two are together, and it's not self-evident that they've been joined. They were joined along together, and now they've been ripped apart in the last decade. Okay, that's the first. No pre-lapsarian moment. Second, the rise of the newspaper owed nothing to copyright, a legal instrument that had been increasingly looked to as a panacea for news, as Will showed, in recent decades. And in particular, following the 1990s, there's been an effort by AP and other groups to enlist historians to become crusaders for the hot news doctrine and such. I've been in that position myself. It's very strange, but it's there, and this is a real, it was so well displayed in the slides. Slaughter's history of copyright, and here I agree very much with Kevin, is in this sense a history as much of paths not taken as opportunities pursued. And some of the recent work of Heidi Tworik is very much in a similar spirit. It's fascinating to study project after project, all these hopes, all these aspirations, and yet they're all kind of fail. Because for Slaughter, other mechanisms, including the barriers to entry devised by newsbrokers, a topic that Jonathan Silverstein Loeb explored in a monograph, have been much more important. And these include some to our own horn, but as Will's horn too. We explored some of these in a book called Making News, where we talked about the institutional arrangements that help to sustain journalism, often non-market institutional arrangements. But there's not copyright, there's a bunch of other things. News doesn't pay for itself. You have to have institutional arrangements to pay for the news. Copyright's not the answer. Okay. So that's the second point. The first is about commerce, second about copyright, and the third is that he dismisses as spurious, I think quite properly, the overly broad claims, this is getting into the weeds, that legal scholars sometimes advance for a 1919 Supreme Court case, International News Service versus Associated Press. That's the subject of his last chapter. It's a very appropriate subject of the chapter because that's an important and much discussed case. In his view, this case was, and here I quote, really about protecting the cooperative arrangements of the AP, Associated Press, at a time when its membership was restricted and newspapers did not yet face competition in using breaking news to sell advertising. And it has to do with trade norms within, what you're talking about, trade norms within the field. It cannot be the basis. In fact, the justice who wrote that decision is one of the most obscure justices in the history of the Supreme Court. You cannot he's not Brandeis. You cannot use this ruling for much kind of purposes it's been asked to be used for recently. The larger context of this ruling, and indeed of his monograph, as he correctly notes, is, quote, larger and ongoing discussion about how to fund quality journalism. Certainly with my journalism school hat on, that is a major concern, and should be pressing concern of citizens. Larger and ongoing discussion about how to fund quality journalism. For news, as Slauter astutely notes, needs, and that's an interesting verb, news needs something. News needs to be treated differently from other kinds of human creativity, and that those needs, or this argument about these needs, includes a cultural argument that news does not seem like a product of authority, cultural argument, these needs, and a political argument that exclusive rights would restrict public access to information. Okay, that's the reason for these needs. I guess I'm almost getting to the 10,000 feet here, but that's where Will takes us. And I want to return to that question of needs at the end. Slaughter's reference to this larger discussion about news funding takes me to the second topic, which I'm just going to speak about pretty briefly, and that's the relationship of who owns the news to scholarship on the news by historians, media scholars, political scientists, and sociologists. Now I'm going to just kind of locate it in kind of a larger landscape. Slaughter's approach, as I read it, most resembles, and maybe disagree, Sam Levivick, Heidi Tworik, Jonathan Silverstein-Loeb, Michael Stamm, Victoria Gardner, Andrew Pettigrew, who decenter news by locating it in the broader political economy. We had a graduate student at Columbia Journalism School a couple of years ago in our PhD program in communications, and he came and he was astonished to discover that none of the faculty members who teach in that program would be willingly describe our approach to communications as media-centric. In other words, we're not media-centric. He was so astonished he left the program. But we're just not, and neither is Will. There's a much larger political economy here, indeed a much more landscape. All right? Slaughter's careful attention to language is particularly important here. This is one of the fascinating aspects of this book. Terms like piracy, property, copyright, even news are by no means self-evident. And as Slaughter notes, they have metaphorical significance that older newspaper-centric scholars often overlook. Once upon a time, journalism historians thought they knew what they were talking about when they talked about news, and we no longer are so confident. The First Amendment, oh, it is mentioned, as Kevin mentioned, it's not a cornerstone of Slaughter's account. I applaud that. Neither is the English Bill of Rights, although there are important changes in the first quarter of the 18th century in Britain. On the contrary, like these other recent historians, he's sensitive to the institutional arrangements that journalists operated in, and in particular to their possibilities and limitations. Right? There's a larger political economy or ecosystem, whatever you want to call it. You don't just start with the newspaper or with the news item or with the report. This is not a media-centric book. Media scholars, I suspect, will find Slaughter's book a revelation. A lot of things surprise media scholars, and should. Particularly when it has to do with what actually happened in the past as opposed to what they think occurred more than 10 minutes ago. With a few notable exceptions, and I'm thinking here of John Nerone's exemplary media and public life, this scholarship lacks historical depth and is preoccupied with simple-minded policy fixes in the United States until quite recently. The most daring radical move of media scholars was that we should have a BBC-style national news infrastructure. In other words, in which the federal government had a key role in provisioning of news. See how that turns out. And these fixes overlook the myriad ways in which governmental institutions and civic ideals have long shaped the news. There's a reason the Brits have BBC and that we don't, and it has to do with a lot of practices, institutions, and values. And that brings me to the simple point that Slaughter's book makes so well, is that the creation and circulation of news has always been regulated. Always been regulated, notwithstanding First Amendment platitudes and all the portentous platitudinizing about master switches. We're all in Slaughter's depth in providing us with such a detailed analysis of just how it worked, What were these institutional arrangements? That's part of the value of this book. So So that's media scholars, who I'm not entirely enthusiastic about as a group. Historical sociologists would find Slaughter's account more congenial. No. And Paul Starr had Who Owns the News in hand when he wrote The Creation of the Media. I'm confident he would have been able to seamlessly integrate Slaughter's findings into that fine book, which is the best history we have, given scholarship he had at his disposal on the political economy of journalism, or the media, as he calls it. So I wonder, this is a question, would Slaughter's narrative lead Starr to make different arguments about constitutive choices? In other words, are there different constitutive choices, different key points? Now that we've got Slaughter, that Paul Starr would say, aha, got it wrong, got to change that chapter. I don't think that's the case, because they have a similar, and I might be wrong, because they have a similar sensibility. For Slaughter, like Starr, has little patience with the technological determinism that shapes so much literature on the regulation of communications. New technologies, Slaughter writes, and here I applaud the sentence, quote, cannot by themselves explain when and why people have lobbied for new legislation or gone to court to stop others from copying. Right? It's not a question of new media changing everything overnight, and therefore regulation follows. There's a tendency to treat the history of media, political economy, as you've got a new media, and then the regulators, oh my gosh, what are we going to do? And then they scurry around to come up with a patch. And then another new media comes about, and they scurry around to come up with a patch. I could name books, and if you'd like, name them by title, that follow that basic form. And it's wrong, it's misleading, and it's not something that you could, I think, easily believe if you've read Slaughter seriously. Well, I think Starr would agree with that, as would, by the way, my colleague Michael Schudson, the world's foremost sociologist of news. So this is going to fit in with literature and sociology. Now let me say something about political theory. Political theorist John Keane is a great student of what he calls monitory democracy. And he would presumably applaud Slaughter's rejection of copyright as a solution to the myriad problems confronting news providers today. Copyright is a bad idea, Slaughter bluntly writes. The risks simply outweigh the potential benefits. This kind of morally engaged scholarship, and I'm lifting up Keane here, is morally engaged in a monitory democracy, in which you need an awful lot of information for deliberation. This is badly needed in a field in which lazy thinking has prevailed for far too long, and it helps to link Slaughter's splendid book with core issues in democratic theory, such as those that Keane writes about. News does indeed, as Slaughter notes, need to be treated differently from other kinds of human creativity. This is because news is essential not only to Keane's monitorial democracy, but also to commerce, public life, and indeed the conduct of daily affairs. So one takeaway from Slaughter's book is that there was never a marketplace of ideas in the past in which news somehow created itself, produced, distributed. And this theme has been forcefully advanced by media scholars, including John Durham Peters, in books, articles, and in a recent interview in the Vatican Journal, Culture, Communications, just came out today, on freedom of expression. And this is not something we should try to create today. In other words, this troubled me. I'm teaching in contemporary civilization. We had an expert in on Mill. And the expert was trying to convince us that Mill believes in the marketplace of ideas. So I raised my hand. Mill never uses the phrase the marketplace of ideas. In fact, what he describes as not a marketplace of ideas is really something really quite different. Yet if we call it a marketplace of ideas, and we talk to the future as the marketplace of ideas, what we have done is we have just become part of the lobbying arm of Facebook and Google and the other big corporations. The same is true, I would say, of a lot of discussion about fashionable doctrines in communication policy, and I won't name the one that I'm particularly troubled by. The institutional arrangements that made possible the creation and the circulation of news have always presupposed a particular vision of the good society. That's evident in Slaughter's book. It's clear on every page. And I think that's one of the ways in which it's going to be assimilated into the literature, in a number of literatures, And it's to this vision of the good society that I believe we should turn. News is as much a human product as healthcare, public parks, or education. And books like Who Owns the News help us to understand not only what to avoid, but also why it matters. We shouldn't fall into those traps of the past. That's what I have.
To respond to what you may.
I really, I mean, these are two incredibly rich and moving commentaries for me. It's always a really special moment to see that you have readers who are taking your ideas seriously and thinking about the different strands of what you're interested in. So I'm really happy to be able to just respond briefly. I can't do justice to all of these remarks, but I think there's a few things that are really important to respond to. One of them is that is the question of why. Almost, you didn't put it this way, Kevin, but almost like it's obvious that copyright wouldn't be the solution. So why are we writing the history of this? And Richard also mentioned this is a history of failed initiatives, right? The attempts to create a copyright law that would actually work for news never worked. So what's the point, really? I mean, neither of you asked me what was the point of writing the book, but I thought about this many times as I was writing it, and I think that there's a couple things. One is that what seems like the obvious limitations of copyright, maybe to a lawyer working today, were not inevitable. And that I think it's really important in the history to reconstruct the fact that, the key sort of achievements or key exceptions, not just the most obvious being like the fair use doctrine, but also this dichotomy between expressions and ideas, or expressions and facts. And I try to show that actually it's often cases about news that pose these questions really clearly and actually forced judges and legislatures to articulate what they thought were the acceptable boundaries. And that actually the fact that it keeps coming up doesn't make it any less dangerous. In fact, maybe the lobbyists would eventually succeed, right? Or maybe the arguments would eventually work. And so I try to show that these resistance to copyright was actually quite powerful in the past, in addition to showing that it probably wouldn't have worked either. So I think that if I'm making any contribution to legal history, it's that looking at the practices alongside the legislation in court cases shows that what people believe copyright to be and what a judge or a lawyer says it is are often different things. And this leads into another question that Kevin asked. Well, why did copyright keep coming back if it seemed to not be a good fit, if it seemed to not be a real solution to the underlying problem? And I've thought about that a lot too, and I'm still thinking about it now, because it's happening as we speak with the European legislation. There's absolutely no empirical evidence that this new publisher's right is going to lead to significant revenue increases for publishers. And so what it is doing, I think, what discussion and rhetoric about copyright does, is it enables people to make moral and political arguments that have to do with fairness, that have to do with justice, that have to do with supporting a quality pluralistic press and whatever, and it becomes extremely difficult to be on the other side of this question. And I have been, one of those scholars saying, but wait, do you have any evidence that this would work? It didn't work in previous cases, including very recent legislation in Spain and France. And you've had 2 or 3 years now when that legislation is existing and absolutely no evidence that it would work. This is not something that any news publisher or journalist wants to talk about, because the argument of supporting the press is crucial to them, and the idea that Google and American tech companies are doing something unfair and pillaging. And so that rhetoric, I try to show that has always been the thing. So clearly, if copyright is one form of subsidy, there were other subsidies, as you mentioned, like direct subsidies. There are also the indirect subsidies, like the postal subsidy, many different types of postal subsidy, actually. Indirect subsidies like tax breaks and special status, nonprofit status for journalistic organizations. There are all sorts of other subsidies that arguably have more of a place. And it doesn't always have to be going all the way to a publicly funded, directly controlled journalism organization. There always have been these subsidies, and so that's really what should be talked about rather than copyright. But I do think this political and moral aspect of copyright is important. The tension with the First Amendment, I think that was a part of the project that I actually just kind of had to set aside. And I think that some readers would actually want more. Richard said he's glad there's not much about the First Amendment, but absolutely. And I think that Kevin's point that if you really created a property right in news, especially one that would cover more than the expression, then you have a conflict. And so that is indeed what I think a lot of the few times it has come up in courts, both in the UK and the US, the argument, the judgments are basically that, well, we have fair use, we have a number of exceptions to copyright, and we have this, doctrine that facts can't be protected, and this basically is enough. This is enough to guarantee that freedom of speech is not restricted. That as long as somebody has the ability to reformulate, as long as somebody has the ability to enjoy an exception for teaching or for news reporting or whatever, that copyright is not fundamentally in conflict with free speech. I'm not sure that that's always enough. There are cases in which, there's no acceptable substitute really for reproducing the exact words. You can think, for example, the fact that somebody said something in a particular way might be what is newsworthy, and then that could be potentially in conflict with that person's right to reproduce it. And images and photographs are something that I could not treat adequately. At one point I was starting to write about the history of protection of images, and I had some things about lithographs in the early 19th century and engravings, and then photography coming in, and could you control the visual representation of news? And I realized that this was just too much for this one book, and so that has to be another project for other people, not necessarily for me, but maybe in part for me. But the photograph is a good example of something where you can't really separate out the fact from the expression all that easily, and you could try to describe a photograph in words, or you could try to recreate the scene, right, and make a new visual representation, but in a lot of cases it wouldn't be adequate to protect First Amendment rights to just say that you can separate fact and expression. So I think that is a real issue. Yeah, I mean, a lot was said about Richard's comments, a lot about the kind of business history or more political economy approach that I took, and I think that that's absolutely true. In many ways, the transformation from my dissertation work, which was about the circulation of news at one moment, was really about reconstructing the practices and how it circulated and what effect it might have had. And then, when I started thinking about copyright, I realized that I was looking at policy choices. I was looking at a series of policy choices and institutional arrangements, as he said, deals, various ways of wheeling and dealing that made a difference. And so that's a clear difference. So that brings me back to the question about news, and that is what I'll end with, because we need to have time for questions and if people have them. You could say that I skirt the issue and I say news is just too difficult to define, and that's sort of what I say at the beginning. But then I say also disputes over controlling news often led to new definitions, and that one of the problems in controlling news is defining exactly what it is. I think in my earlier work, in my sort of work on focusing on the circulation of news at a particular moment, my definition of news would have been, news is a collective textual process. That's a little bit wordy, but in other words, news is not just some cultural historians have said news is culture, right? It's defined by culture. Some have said news is, whatever you can't wait to tell anybody else. Some would say news, like pornography, is something you just know when you see it. I think one of the things that is distinctive about news as opposed to journalism is that news is almost always, a collective enterprise, and it doesn't really mean anything outside of the interactions that shape it and give it meaning. So that's the best I can do in defining news, especially as distinct from a different category, which would be journalism. And that, of course, there are many different types of journalism. But in this book, I'm not talking about long-form journalism. I am talking mostly about breaking news, and it's the kind of bits of information, bits of stories that circulate in a very sort of collective way. Okay, so I think I'll let other people.
Wonderful. Thank you so much. I'm going to open it out to questions from the audience and responses from the panel, kind of both at the same time. I would love to use, I was hoping for a little bit of silence, to use my prerogative as a moderator to ask a question myself, which is to do with fake news. And one of the enormous strengths of this book is that it historicizes terms that we think we know the meaning of. So for example, piracy or falsification, copying, and gives a really granular history of what those terms meant at the time, a very careful history. And so it does what the best history does, which is make the familiar unfamiliar again. And so I was very surprised to find a couple of examples of fake news inserted into 18th and 19th century British and US newspapers, not as we think of fake news now, which is either a presidential invention or a means of spreading propaganda, right? But actually as a form in the 18th and 19th century of entrapment. So I was in a way to entrap competitors who were in the engaging in the practice of copying news. So I was wondering if you could say a little bit more about some of those instances in the history that you wrote, and what the kind of very particular historical texture that you have studied so deeply in this book might lead you to think about some of the current discussions of fake news. You have a very unique perspective on this issue.
Okay, that's a big big question, and actually, for me, two different kinds of question. One on using fake news to trap pilfering rivals is, in a way, a part of the story of self-regulation that Kevin was asking about. Well, journalists, even before professionalization, editors and newspaper publishers were policing each other. And using fake news, deliberately planting stories in hopes that your rival will copy the story and then be embarrassed because it will have spread misinformation, strikes me as a very desperate form of self-regulation. In other words, this is after you've asked them to stop copying, and after you've said things like, oh, well, if you copy from us, you really should credit us so that we get some, so that we get a boost in our reputation. And so planting fake stories was only one technique on a continuum of, trying to, publishers and editors trying to create shared norms about copying. What could you copy, and if you did, would you, how were you supposed to acknowledge it, and so on. And so in most of the cases that I recount in the book, these are particularly desperate moments where the enterprise, the business that has spent money collecting news is just so upset that other people are profiting from it that they insert these fake stories, and then it usually backfires, because then when this is found out, the rest of the press gangs up on them and says, look, you've actually done much worse by perpetuating this fraud. You've done much worse than copy news, since when we copy news, we're spreading accurate information. You're making up fake information, and so this is not. But it is surprising that it's something that comes back. And it's in the age of Hearst and Pulitzer, they were doing this right up to that point, if not later. So that's it. And then there's also the question of whether fictional news could actually be protected by copyright also comes up. In fact, one of the judges in the INS case authors an opinion in which he's, an author, basically made up a fake courtroom scene, and it was like a short story, but it was buried in the newspaper in a way that it looked like it was a real story of what happened in a courtroom. Well, then a playwright used this to create a play, a courtroom scene play. And the first author actually sued and said, you've infringed my right to dramatize my short story. And the judge said, well, no, actually, this was presented to the public as news and as a factual occurrence that happens, and nobody can own this factual occurrence. So it actually, again, it was a moment where judges have to define that. Your broader question about putting fake news in perspective is an important one, but I'm not sure I can do justice to it, except to echo what a lot of historians have said, is that, the full range of misinformation is so big, and I think one of our real mistakes is using that term fake news. I remember when fake news was Jon Stewart, and watching late night comedy, that was fake news, and now it's something else. But certainly hoaxes and misinformation and planted stories have a long history, and the real change now is a change of scale and a change of a degree of violence that is created by the way these things circulate now, which is just not the case in previous forms of periodical news. It's just a totally different scale now. So I certainly would not say that this problem the problem we're dealing with now is not always, that problem has not always existed. The kind of fake news on that scale.
Great, thank you. Any other questions or comments from the panel or from the audience? Yeah, Emily.
I have a question about the extent to which you talk about other ways of owning the news. And I'm thinking specifically like guilds and unions, and for instance, with the formation of the BBC, one of the groups that was most adamant at sort of fighting the formation of the BBC in the UK were, unions of journalists who felt like they had a sort of ownership in the news as a concept, right? And that they felt like the BBC was infringing upon their sort of ownership of the news. And when the BBC started with its house organ, the listener, they had to agree that they would publish 90% of stuff that came directly from radio, and only 10% could be original content, because that would be considered like news. So I'm curious, whether that sort of comes up against what you're talking about with copyright, if there's sort of a larger story of institutions, unions, guilds.
Yeah, that's, the guilds are actually very present in the early part of the book because they were printers' guilds and booksellers' guilds. I think the history of labor of journalism is something that's crying out for historical research.
Yep.
And that's something that I could not, you have the history of freelance labor, the history of salaried labor in journalism, all of that. If that literature existed, I would have loved to weave that in. But I realized that I could not do that on my own for this book, which was already covering this long period. But people are starting to look at, even in the late 19th, early 20th century, as you're saying, the way in which journalists are organizing and are thinking about these sorts of things, and that would be an important part of the story. The BBC, the opposition between newspapers and the BBC is interesting, and there was a similar thing that happened in the United States, and the AP was at first very worried about broadcasters because it threatened their cooperative business model. If suddenly you could transmit news that would go across territories, circulation areas of newspapers, suddenly you're disrupting that whole thing. So there was a period of 10 years or so where this was being worked out, and some of it was making deals like what you just mentioned, like agreeing to limit broadcast to a certain time or a certain number of minutes and to not do advertising. All these kinds of deals were part of it, and in some ways that's come back with the internet. The attempt to negotiate fair practices with technology companies is very reminiscent of that moment where radio came in and it disrupted. But eventually, in the long story, and Richard mentioned Michael Stamm, talks about how eventually newspapers realized that they could partner with radio, and that they actually, that there's more than one type of news. There's the type of news which which you recount on the radio as it's happening, which is a very different type of news than making a story about something after it's happened. And so, newspapers realized that they could actually play in this sort of multimedia space and have radio stations that would do a different part of the business of news. And so that's what they did, whereas in the BBC, in the end, I think newspapers were pleasantly surprised that the BBC didn't ruin everything. In fact, it arguably helped because they didn't have small local radio stations that they were competing with in their own towns. I mean, they just had the BBC, and it kind of limited the threat in a way, especially with advertising, classified advertising.
So thank you for this. This is a fascinating, all three of the presentations were just totally fascinating to me. But this question comes from a place of not knowing about any of this, and I'm sorry that this is probably a really elementary question. But I'm wondering if any of you can speak to, but particularly whether this is covered in the book, two things that didn't come up in the discussions, which were investigation and opinion. I take it that, I'm guessing, although I don't know anything about the EU's proposed legislation, that there must be some impulse to make investigative reporting somehow an especially protected aspect of this, or I don't know, and I'm guessing that opinion then would be an end run around anything that the EU because once the reporting is out there, then you can express an opinion on it and get facts that way. So I guess my general question though is how investigation and opinion work into the fact expression dyad, the story of the fact expression dyad that you're talking about.
Yeah, I try to show that even in the 19th century, the publishers are not worried about what we would now think of as like longer form journalism. They sort of take it for granted that copyright would protect, a particular version of events. What they're worried about is protecting this just raw details. And so that's where most of the litigation, most of the legislative effort is. And so, yeah, they're not even, but the thing is they're not even using copyright really to protect longer investigative pieces or opinion pieces. Right. Because that's not really what's being copied, right? That's not the kind of free writing that they're worried about. When that stuff is copied, they absolutely want it to be credited. Like, this first appeared in X paper, even before individual writers are mentioned, just name the paper. The EU legislation is really about recognizing that copyright has limitations, and one of the historic limitations that's built up over time is that you don't have copyright for titles or short phrases. So there's a certain threshold of length that's, it's changing, right? We were now down in the EU to 11 words is certainly enough, because there was a case that, a media monitoring company was taking a keyword identified by a computer and 5 words on either side and showing that snippet. And the court said, all the way to the Court of Justice of the European Union that, okay, 11 words, that's enough to show potentially the intellectual creativity of an author. However, they haven't historically protected titles, which in the case of news would be the headline. And so that's why search engines and Google News and stuff can get away with snippets, especially the headline, because we've always thought of titles as something that we need to be able to cite, right? To have any kind of discussion or whatever. And so the idea of a copyright for a title is anathema, and that's that's built in over time. So really, this legislation is about removing all of these exceptions and creating a special right that would apply from the minute you copy the headline or any small number of words. It's really about that. It's not about protecting, because journalistic articles are automatically protected by copyright. This is what they're doing. This is what they want. But the public-facing campaign is like, you're not protecting journalism. Journalism isn't protected by copyright, which is a lie. It is protected by copyright. It's just that copyright has these limitations, which have been built up and are supposed to be a kind of safety valve to make sure that we can still cite each other and quote when we need to, short quotes in order to demonstrate points and opinions and so on. So it's really about, and they claim that they would only apply that to the big tech companies. They wouldn't ask individuals to do that. In fact, the latest draft, individuals are exempt. So you could still benefit from the exception for short phrases and titles. It's just that Google and Facebook could not. So they would have to get a license even for the small thing. And so it's, in my view, it's a very clunky way of trying to redistribute some of the profits that Google and Twitter, well, not so much Twitter really, it's not been the main, but mostly Google and Facebook, right, are the main. They see how much money Google and Facebook make from advertising, and they say, well, actually, part of that should be for the news organizations that produce the content, right, that they're using on their platforms. And so you can understand that fairness argument. It's just that copyright is a very blunt way of doing that. And only now, recently, people are starting to talk about other things like, well, maybe if you tax advertisements, and then you take part of that tax revenue and you redistribute it to journalism. You create a fund for journalism that would be, based on a tax rather than this regulation of copying.
Please.
Has this project changed the way that you read the news?
It's a good question. I've become much, I think this is not particularly original. I think most people who read news in the age of social media and in the age of just the web in general, even before social media, you start to notice the way stories flow and the way a lot of the material is not unique or not original, right? So and this it used to be that if you only read one or two newspapers, you didn't know what percentage of your local newspaper was original and what percentage was derivative from press agencies or derivative from, just summarizing or copying what had been done elsewhere. And now this is very visible, right? Now we see it, and so I think it's not from writing the book so much as living through that, but it does make me think about the fact that, if these news organizations really did want to be serious about copyright, actually, if 66% of all French news articles are copied, well then actually they should be getting a license every time they do that. But basically they're not going to sue each other, right? Because that's not what they want to do. So they've developed norms which are not in strict compliance with copyright law. But as long as they don't sue, they can continue to do that. And so that, I would say that that's about reciprocity, and that's about making a distinction between news organizations giving each other a little bit of leeway because it's useful to be able to do this, and it wouldn't make a whole lot of sense to have always an independent reporter, gathering the same fact or copying down the same speech. That might be not necessary, but once a technology company, which doesn't employ journalists, starts doing that, that's where it becomes a problem. And so it's a lack of reciprocity, which means they now want to enforce copyright rules that they wouldn't enforce on each other. That's sort of my take on that.
I'll just add briefly that when I was trained as a magazine journalist, I also worked as a fact checker, and through that process you do learn to the extent to which the news that you read is a collage. And so one of the very interesting things about reading this book was learning about the history of that collage and the kind of gentlemen's agreements among the competitors that cropped up in order to protect that and who is now being excluded from it. That's it for time, so I'm just going to say thank you so much for joining us. Thank you for the excellent comments, and congratulations on your fascinating book.